Good afternoon, everybody. So, my name is Päivi Keskitalo. I'm working in the Non-Discrimination Ombudsman Office, Senior Officer and Monitor of False Returns. First, I would like to thank you, the organizers, for the invitation to this very interesting and current seminar. In the morning session, we had a very important keynote speech about post-deportation monitoring, but unfortunately we are not yet there in Finland. But I hope that one day we will be. Okay, first I tell you shortly about the Non-Discrimination Ombudsman. The task of the Non-Discrimination Ombudsman is to promote equality and prevent discrimination. Discrimination, according to our National Non-Discrimination Act, is based on age, origin, nationality, language, state of health, disability, sexual orientation, and so on. The Non-Discrimination Ombudsman is an independent authority that belongs to the administrative branch of Ministry of Justice. The Ombudsman also works towards improving the rights, circumstances and status of groups at risk of discrimination. The Ombudsman further monitors removal of foreign nationals from the country and is the national rapporteur on trafficking human beings. As a monitor of forced returns, the Non-Discrimination Ombudsman supervises through the process the enforcement of the removal from the country of foreign nationals who are subjected to refusal of entry or deportation. I'm a lawyer by profession, so I'm sorry, but I can't just forget the legal framework for monitoring. Well, sometimes the authorities have to use forcible measures during involuntary removal from the country. Between 1991 and 2015, a total of 17 deaths were reported in connection with the removal from country in Europe. Deaths have occurred in countries such as United Kingdom, Germany and France, among other countries. And the latest case that we know happened in Sweden last spring 2015. Most of these deaths resulted from suffocation due to the improper use of force. In Finland, no deaths or serious injuries have been reported. So, due to serious violations of the rights in EU member states, an article included in the so-called Return Directive, stating that member states must have an effective forced return monitoring system. Independent external monitoring was considered to improve the legal protection of both returnees and escorts and prevent excessive use of force and other prohibited treatment. And as a result of this, Section 152b was added to our National Aliens Act, whereby then the Ombudsman for minorities, which is now the Non-Discrimination Ombudsman, is required to monitor removals from the country. This legislative amendment entered in force in January 2014. The above this section of the Aliens Act it's very broad and general in nature. It stipulates that Non-Discrimination Ombudsman shall monitor the enforcement of the removal from the country in all of its stages. This covers all measures related to the removal, including voluntary return. The monitoring obligation imposed by the Return Directive does not define the substance of monitoring in any way. The article in question only says that the member states shall provide an effective forced return monitoring system. Also, in Finland, the National Police Act and the National Police Board's instructions regulate the police activities in enforcement of removal orders. After the monitoring became the duty of the Non-Discrimination Ombudsman, we started to build up and develop the monitoring system with some challenges. The legislation doesn't give much advice how the monitoring should be organized, and there was no previous experience of external supervision of the forced returns. And there's a lot of confidential information about the enforcement on individual returns. So we started our job by studying and finding out how the police do the enforcement of the removals. But at the same time, we also began implementing practical monitoring measures. We got guidance and help from the CPT recommendations, 20 guidelines from the Council of Europe's Minister Committee, and Frontex guidelines. We paid study visits to Denmark and Netherlands, who have long experience in monitoring. We have also participated in EU training for monitors organized by Fundamental Rights Agency and Frontex. And at the moment we are partnering the EU-funded forced return monitoring project, which aims to further strengthen the quality of the European return system in line with the fundamental rights standards and best practices. CPT recognizes that it will often be a difficult and stressful task to enforce the deportation order in respect of a foreign national who is determined to stay on the state's territory. And according to the CPT's experience and studies, deportation operations by air entail a manifest risk of inhuman and degrading treatment. So, preparing for removal is essential. Operations involving the deportation of foreign nationals must be preceded by measures to help the person concerned organize their return, particularly on the family, work and psychological fronts. It's essential that the devotee is informed sufficiently far in advance of his or her prospective deportation so they can begin to come to terms with the situation psychologically and are able to inform the people they need to let know and to retrieve their personal belongings. The CPT has observed that a constant threat of forcible deportation hanging over returnees who have received no prior information about the date of their deportation can bring about a condition of anxiety that comes to a head during a deportation and may turn into a violent, agitated state. Fit to fly examinations should be arranged to all, or at least in cases in which there are health concerns or in cases where the resistance is expected. CPT recommends that all persons who have been the subject of an abortive deportation operation must undergo a medical examination as soon as they are returned to detention. One of the key issues when a deportation operation is carried out is the use of force and the means of restraint by escort staff. The CPT acknowledges that such staff is, on occasion, obliged to use force and means of restraint in order to carry out the deportation. However, the force and the means of restraint used should be no more than is reasonably necessary. Also, the principles of lawfulness, proportionality and appropriateness should be taken into account. Use of force should always be the last resort. Positions or means in which there is a risk of asphyxia are absolutely forbidden. Most of the reported deaths have been caused by asphyxia, suffocation. Deportation operations must be carefully and systematically documented. The information recorded should cover every incident and every use of means of restraint, meaning handcuffs, ankle cuffs, knee cuffs, use of self-defense techniques, carrying the deputy on the board, and so on. And clearly, escort staff must be selected with the most utmost care and receive appropriate specific training designed to reduce the risk of ill treatment during the And here's a European definition for monitoring. It's an activity whereby it's established and reported whether the return is conducted in a human manner, respectful of the dignity of the person and in compliance with the fundamental rights. Monitoring involves observation and reporting, but it's very important to recognize and remember that monitors have no powers of intervention during the operations. Presently in Europe, states use a variety of systems. In some countries, national prevention mechanism implementing the optional protocol to the UN Convention Against Torture, OPCAT, have been tasked to monitor forced returns. In other countries, NGOs, internal police monitoring systems, or national ombudsperson have been called upon to carry out this monitoring function. Moreover, at European level, CPT is mandated to visit all persons deprived of liberty, including persons involved in return procedures. And external and independent monitoring strengthens transparency in post-return operations. And it can reduce prejudice against police operations, and it can protect also escorts against false accusations of using too much force in the return operations. And forced return monitors have to be aware of their impartial role, their specific mandate, tasks, and responsibilities. For example, when we are assessing the use of force, we can use a checklist with the following questions. Did the returnee receive sufficient information? Did the escorts communicate clearly the use of restraint measures to the returnee? Did the escorts make use of de-escalation and communication skills prior to the use of force? Was the use of force proportional? Was it necessary and in accordance to the law? Was the use of restraint measures in accordance to the law, and whether necessary and proportional? Was there an individual risk assessment of each returnee prior to the measures? Did the escorts align with their reporting publication of incidents in relation to the use of force? And how long were the restraint measures used for? Was the length reasonable or excessive? Our mandate in Finland is quite wide, like I mentioned, and it covers even voluntary return. And due to our very limited resources, we have to choose which returns to monitor. Referring to the fact that enforcing a deportation order is often a difficult and stressful task when the deputy is strongly resisting, and there is clearly a risk of inhuman and degrading treatment when the police has to use force in order to enforce the deportation order, we have focused our supervision on escorted returns. And from those, especially the cases where the returnee belongs to the vulnerable groups like families with children, single moms with small children, trafficking victims, people with mental or physical health issues, or when there are difficult receiving countries like Afghanistan or some African countries. We get the information of saluted flights from the police twice a week, and from those lists we can pick up a certain returns to closer scrutinize. We can also get information from the legal advisors, from the returnees themselves, and from their families and friends. Until now, the Finnish monitors have taken part in 20 return flights, including Frontex joint return operations, national return operations, and individual forced returns by commercial flights. In addition, we also observed the departures of returnees from Metsälä and Joutseno detention center, and also from the reception centers and from the places people live. Returnees live. When we don't, we can also follow these operations, and some of them until the returning seated on the airplane, and then we don't necessarily go all the way to the destination country. And here are some conclusions based on our observations. Measures taken by the Finnish police are mainly appropriate and professional. And I underline this, that at least in those cases where the monitor has been at present. Escorting is a special task, and therefore training in special circumstances, like in a very narrow and restricted space inside an aeroplane, is essential, especially in the perspective of avoiding or reducing the use of force. Last year there were about 450 escorted returns, and the monitors, due to the lack of our resources, can participate only about 10 returns per year, or 10 flights per year to the destination country. So accurate police reports of forced returns are important, especially if coercive methods have been used. We can read the police reports and get information from them, but unfortunately some of the reports are quite empty. They don't give much information about the operation. Reception centers and detention units play a key role in preparing returnees for departures. Police and reception centers should improve their mutual trust and cooperation. Some legal advisors seem not to follow ethical standards of the legal profession and can give false hope to their clients, from which can follow serious misunderstandings and problems. Sometimes decision-making in cases of vulnerable persons seems to cause unreasonable consequences. For example, Dublin decisions to Nigerian female asylum-seekers who end up back in prostitution in the circumstances of human trafficking after return to Italy. Also, the return decisions for families with children who have integrated very well in the society feel unreasonable. And at the moment there is a lot of discussion about the quality of procedures and decision making in immigration services in general. So what can we do as monitors? During the monitoring journey, the monitor can ask questions from the head of the escort team and express observations. But like I mentioned earlier, the monitor has no authority to intervene in the execution of the return operation. Based on the information and experiences collected from individual return operations, the Ombudsman can provide authorities with proposals, recommendations, statements, and advice related to the enforcement of removals. At this stage, our goal is primarily to influence the authorities so that the removal practices and the respect fundamental and human rights are included in the internal guidelines of the police, and that they become a joint operating model for all the parties involved in tasks related to removals from the country. final. We can assume that there will be a remarkable increase in forced return operations in the near future because of the current refugee situation in Europe. And it will be even more essential that all the member states will have an effective monitoring system which improves and strengthens the fundamental rights perspective in these very difficult and sometimes challenging operations. Thank you.